Nice to see everybody, and thank you for asking me to do this today. Just as a bit of an introduction, for those people that don't know me, my name's Jamie Middleton. I'm the lead professional for social work and social care within the mental health services in Sheffield. Basically, that I used, first, again, some people will be aware I used to work at Rampton, and I've still kept in touch, even though I've moved on. And it's through those contacts that I suggested, this is happening. Is it something that might be useful for you? So this document, basically, that the government's produced is trying to summarise the proposed reform to the Mental Health Act. It's a really big document, so I've had to try and condense it down. So I'm going to do my best. But please bear with me. But I've titled it A New Dawn or A New Yawn. Basically, I think that as we go through it, you'll see that actually there's quite a lot of proposed changes which could be quite significant and deemed quite radical. But then there's the other part of it, which is actually, will it really happen? Because we've been here before. So is it going to be something or is it not? So I think I'm going to kick off with this. So hopefully these buttons are going to start. So just in terms of the background, this is going to be a whistle-stop tour, right? Obviously, there's only an hour that we've got today, so I'm going to be, I will be as quick and concise as possible. I'm also very conscious that there's quite a broad range of people that's joining today, so not all bits of this will apply to absolutely everybody, but hopefully it will become clearer as we go through what the changes may be. Just in terms of the background, 2017 the government commissioned independent review then into the Mental Health Act because of concerns that it basically was out of date. They commissioned that, and then in December 2018 the independent review was published, 322 pages long, and 154 recommendations were made. So just a few changes around the edges, so to speak. Then obviously COVID hit, which unfortunately meant that the independent review and the government's response to that was delayed. But in January 21, white paper was published by government in response. So at the moment, where we are at is that we're still in a consultation phase, or rather the government still is, up until the 21st of April. So what I'm going to go through today is a summary of that government white paper. I've mentioned about 154 recommendations were made altogether, and the vast majority of those recommendations have been made by the government, have been accepted rather by the government. But I do urge just a big note here is that this is consultation, this is not the new law yet. Things may change depending upon what feedback is given as part of the consultation period, and of course it would still have to go through a parliamentary process, and also it will be subject to the spending review. A lot of the amendments will not apply within forensic settings, but again, I will come on to those hopefully as I'm going along. Okay, so some of this is unfortunately going to be chalk and talk, so to speak, so please bear with me. So, kicking off, the first proposal is for the new guiding principles to be introduced, and you'll see here that there's 4 key principles that the government are currently proposing on around choice and autonomy, of course least restrictive, which we know, therapeutic benefit to the individual, and about treating people as individuals. Now what the government is proposing is that the guiding principles should become enshrined within the law, so just similar as it is in the Mental Capacity Act. And the Mental Capacity Act guiding principles are actually in the legislation itself. At the moment for the Mental Health Act, it's only in the Code of Practice. So the government is hoping that by putting these into law, it will give these more teeth and give them a bit more consistency. but they're also talking of widening out who the guiding principles would apply to. But the white paper doesn't give any more information, unfortunately, about what they mean by that and who that's going to be potentially widened out to. The government is not happy in terms of increased rates of detention, a lot of inequalities, particularly for people who come from BAME backgrounds, and also about increased lengths of stay, so the LOS length of stay. So the proposals are that the criteria to detain people under the Mental Health Act are going to be tightened up. And the criteria is going to be based around two key principles: that there needs to be of a therapeutic benefit to that individual, and that it is, if detention is needed, it is the least restrictive. So they are recommending and proposing changes to the wording of both Section 2 and Section 3. The recommendation, which is accepted by the government, is that people will not be allowed to be detained purely on the grounds of autism or a learning disability. But again, I will come back to that shortly, because that is going to be different when it comes within a forensic sites. And again, just in terms of the definitions, the proposals are for Section 2 and Section 3 to be worded something along the lines of it: you're not going to be able to detain unless there is a substantial likelihood of significant harm to the health, the safety or welfare of that person, or the safety of others. And what the government is hoping is that by these definitions becoming a bit more tighter and a bit more higher in terms of thresholds, they're wanting to ensure that people are only being detained under the most serious of cases. The government is also hoping that it's going to make it clearer in terms of the detention criteria. I'm not convinced by that personally, because introducing the concepts of substantial likelihood of significant harm, well, of course, what is harm, what is significant harm, what is likelihood, and at what point is it a substantial likelihood? So I suspect that there's going to be quite a few legal challenges if this does come into place around how that is actually defined in practice. As soon as, if somebody is detained under the Act, the proposal is that as soon as that individual no longer meets the criteria for detention, then they are to be discharged from that detention, and that to keep them within the hospital would be unlawful. And what the predominantly the RCs are expected to do is to continue demonstrating and documenting why the person is still being detained. They're also going to be, as I mentioned already, around the criteria for detention, but also changing the criteria for CTOs, and also new powers for tribunals. Again, just to note, the definitions that I've just mentioned, they're not proposing making definitions around the grounds for detention if it's a part under Part 3. The proposal again is to give patients much more rights to challenge their detention. So again, going back to the guiding principles around the autonomy and choice, people's rights, the government is wanting to give much more control to service users. So because of that, what they're talking around is allowing patients to be able to make more applications for tribunals. So the intention is for Section 3s, the intention is for service users to be able to challenge that detention 3 times within the first year. So one within the first 3 months, the subsequent 3 months, and then the subsequent 6 months after that. The intention again is to give greater access to the mental health review tribunals. So as I've mentioned there, in terms of being able to make more applications. They're going to be extending the time scale for which people who are detained under Section 2 can challenge their detention. So at the moment, I think it's you've got to apply within 14 days. That's going to be changed and extended to 21 days. And as I've mentioned there, for the Section 3 opportunities for tribunals in the first year. The proposal is to give more powers to IMHAs, so for instance, allow IMHAs to be given the power to apply for patients' tribunals. But also the tribunals are not only going to be considering the actual detention criteria, but they will also be allowed to consider the actual care and treatment plan which is in place for the individual. It's not so much about the plan itself, but it's much more around the justification for that plan and whether the restrictions are proportionate. The intention is that the frequency of which patients get referred automatically to tribunals is to change. And basically, so if you're section 3, for instance, there'll be an automatic referral at 4 months if they've not had a tribunal, and then it will be 12 months after the initial detention, and then after 12 months. CTOs, they're proposing, if they've not had a tribunal within 6 months, again, an automatic referral, and then every 12 months. It will impact on part 3, so your forensic patients. What they're looking at is that there will be a automatic referral for patients every 12 months compared to every currently for 3 years. And in terms of service users who are subject to conditional discharges, they're proposing bringing in an automatic referral at 24 months and then every 4 years. So I think that is going to have quite a lot of impact in terms of resources upon the mental health review tribunals, who's obviously going to be expected to be doing a lot more of them, and also a lot more pressures upon services, because it's going to mean a lot more report writing and tribunal attendances. If we go a little bit further again in terms of the tribunals, so I've mentioned already that the government is wanting to extend the powers beyond just considering that of detention. So they're proposing giving powers to the tribunals to actually grant leave. Sorry, I can hear someone talking.
Jonathan.
Excellent, I've got you back. So my apologies, stumped me a little bit there. Proposal is to extend the powers of the tribunals to also allow tribunals to order and grant leave to transfer patients, and to also, interestingly, direct services in the community. So that's quite a broad power, and I think potentially quite a really big impact upon us within community services. So as I've written here, the proposal is to put a legal obligation upon both health and local authorities to follow what a tribunal decides. Now, if authorities are not able to do what the tribunal does, there will be a formal process that they will then have to follow to outline what steps they've taken to try and implement the tribunal's decision, and if they've not been able to, they will have to explain why it's not possible to do so. These powers, though, will only apply to unrestricted patients, and they will only form part of a pre-existing appeal. So what I mean by that is that someone will not just be able to apply to a tribunal to try and get moved to another hospital, for instance, or for leave. It would have to be considered as part and parcel of a main tribunal hearing. In terms of rights to refuse treatment, again, this is going to be tightened up, and service users and patients are going to be given more rights to refuse. So I'm just going to introduce these new concepts. One proposal is around implementing an advanced choice document. So as I read it, it sounds very similar to an advanced decision. But this one would be in terms of what your wishes are and what your refusals would be for if you are ever detained. And within that, you will be able to put down that if you wish to not have certain treatments, for instance, in the event that you lacked mental capacity. And what will happen, what will be a requirement, is that the hospital or the RCs there will be a legal requirement to basically comply with these advanced choice directives insofar as is possible. They will be able to get overruled under certain circumstances, but we'll come back to those. There's going to be care and treatment plans which will be put onto much more of a legal footing, and there are going to be timescales and legal timescales in which these will have to be made up. And again, I'm going to come back to that in a second. In terms of Part 4, so Part 4 of the Act is around when about the giving of medications, for instance, and treatments, when people can have them, when they can consent, if you've got to have SOADs, for instance. Those are going to be changing. Again, I'm going to come back to that. And I know I apologise, I'm repeating some of this, but more of a role around tribunals. So if we just talk a little bit further then, firstly around these advanced choice documents. So again, similarly with an advanced decision, the intention is that these documents will only be valid if and when a person has written them at a time of having mental capacity. And these documents are only considered when a person loses their mental capacity. And what is written in the document will be deemed as though they've got mental capacity at that point in time. I've mentioned already that it will be a legal requirement for these documents to be considered. Now, what I thought was quite interesting is that the consultation paper is saying is that if someone has previously been detained, then it suggested that they are proactively encouraged to do an advanced choice document, and that they're also aiming to put into law a requirement that an advanced choice document is to be offered to all people who have previously been detained. One thing that went through my mind with that is, well, what does that actually mean in practice? If you're talking about if by law we've got to offer this to all people who've been previously detained, well, firstly, under what part of the Mental Health Act? What if you'd been brought in on a 136? What if, for instance, you were detained at the age of 17 and you're now 40? Have we now got to go back how many years worth of doing this? So there needs to be a lot more clarity, in my view anyway, about that. And again, anyone at risk of detention should be offered one. So I think that that is an interesting one, again, because if you're trying to build up a relationship with someone, but then you start talking about having this document in case you lose capacity, there's benefits to that, but also potential downfalls to that. There's also a recognition and learning from the Mental Capacity Act, where a lot of health and social care professionals struggle to find out if someone has got, for instance, a power of attorney, or if someone's got advanced decisions and advanced statements. So the government is proposing that these advanced choice documents will be accessible to all, presumably all health and social care professionals, but via a secure digital database. So that will be interesting, but there's no more information in the white paper about what that would actually look like in practice. So these advanced choice documents, the intention is for them to be standardised. I won't go through the whole list here, but you can see that there's a wide range of issues to be written and considered. So for instance, who's to be notified if the person is detained, religious, cultural requirements, crisis planning. The most important thing for me there is, of course, the pets, which people who know me won't be surprised by that. And again, treatments that they don't consent to. And again, the emphasis is that there's going to be legal weight to the advanced choice documents, and the intention behind the government is, in their wording, is to give patients real power and influence over their decisions and around appeals against their treatment. And as I've mentioned already, is that when these statements are made, they're taken as though that the person does have mental capacity at the time. There has been a question raised about how do we know that these advanced choice documents were written at a time that somebody had got mental capacity. So there was the idea has been put forward that they should be countersigned by a mental health professional or a health professional at the time to confirm that they had mental capacity at the time of writing it, but the government is not proposing on that. Their view at the moment is that that will be a matter for the staff who are concerned at the time. So again, I can see a few solicitors' eyes chinging with a pound sign. Again, maybe that's my cynicism. In terms of the care and treatment plans being put onto a statutory onto more of a statutory footing, the intention is that all patients who get detained under the Act must by law have these new care and treatment plans, and again a number of standardised expectations, one of which, for instance, going to have to demonstrate how the patient was involved with the devising of that plan, got to demonstrate how we've taken into account patients' wishes, be given legal rights to see their care plan, which I'd be expecting people should have anyway, which includes the plan for discharge, and again the responsible clinician will be responsible for doing this plan. If there's a deviation from what patients want, it must be justified, recorded and explained within that. And that if treatment refusals are being overruled, then again the RC will need to evidence and document within these statutory plans what procedures, what they've followed to make sure that it was done lawful. And if we're talking about a service user who's also got a learning disability and or autism, there'll be a legal expectation that the RC will take into account a care and treatment review of that person. In terms of the care and treatment plans, proposed content, again I won't go through the whole list, but I think what's interesting is and really useful, again, areas of unmet need, particularly around medical and social, and also around, from an equalities point of view, around protected characteristics and how the care plan will take those into account. I thought it was quite interesting that the proposal is also for the plan to contain information, the plan for readmission after discharge, e.g. an informal admission, a civil section or a recall. So I just thought it was interesting that on the one hand the government, and this is coming about as a result of we don't want as many people being detained, and then they're proposing, but within this we're going to have we need to be writing about the plan for readmittance. But again, maybe that's just how it's been written. It might not be that in reality. There's going to be statutory time limits and time scales. So for patients on a Section 2 or a Section 3, the proposal is that these new care and treatment plans must be done within 7 days of the patient's detention. And then that care and treatment plan must then be reviewed by either the medical or the clinical director within 14 days of the patient's detention, and that the medical or clinical director will then be expected to review that care and treatment plan is sufficiently comprehensive and that they're also satisfied that the criteria for detention is met. There's also a very keen interest and focus on preparing for discharge as soon as you get admitted. So again, there's an expectation of a home first approach. But again, it'd be interesting to see how that plays out in reality. So if I move on to consent and refusals to medical treatment. So again, going back to what the government's wanting to do is to give much more power and control over to patients and service users around their care and treatment. The government is wanting to make changes to the current provisions in Part 4. So they're planning on introducing categories of treatment, really. So category 1, for instance, your most invasive, which would be neurosurgery. A category 2, still invasive, such as ECT, and your category 3 would be more or less every other medical treatment for a mental disorder. And I think this is where it's going to start getting complicated. So if an RC is intending on neurosurgery, the intention is to keep the current safeguards which are in place, keep those. So for instance, there's other doctors, for instance, that need to agree. I think the CQC have a role in overseeing category 1 treatment, so that's to remain. If someone needs medication and treatment which comes under a category 2, the intention is that if the patient has got mental capacity and refuses it, then it will not be able to be given ordinarily. But it could be overridden if it was urgent, i.e. necessary to save patient's life, to prevent a serious deterioration. But under those circumstances, the RC is expected to have to apply to court for that and to have 2 medical opinions to support it. If, however, that there's no advanced choice decision and the service user patient does not have mental capacity for the decision, they will still require a SOAD. But the SOAD in their decision making will also have a legal requirement to consult more broadly when making their decision. So for instance, having to consult with the nominated person, the NP, which I will come back to, and family members. Treatment urgently could be given before a SOAD, but if that happens, the CQC, the RC will have to contact the CQC to notify them and provide details and evidence as to why they needed to do that. In terms of category 3, which probably isn't for most treatment, if we bear in mind currently the first 3 months is that the RC can give whether you give consent or don't give consent. It's only after 3 months that a SOAD would be needed if you're objecting or lacks capacity, but that's intended to change. So again, is that if the responsible clinician wants to overrule and give, the SOAD will be needed from day 14 and not from 3 months. And that's going to apply to those who've got capacity and are refusing, or to those who do not have mental capacity but have a valid advanced choice decision. But overall, the timescales generally is going to be reduced from 3 months to 2 if you've got no mental capacity and no advanced choice document. So again, I think this is where it starts to get a bit complicated. Just got to try and visualize it a little bit better. So if treatment is deemed to be urgent, the RC will be able to overrule whether the patient has got mental capacity or has got an advanced choice decision. They can overrule that without a SOAD if it's necessary to save life, prevent a serious deterioration, prevent the patient from behaving violently or being a danger to self or others. And then there's a 4th condition which currently exists around to alleviate serious suffering. The government's proposing a change to mean that the RC can only overrule on that ground if the patient lacks mental capacity. So in other words, they're introducing the right to choose to suffer. But again, is that only will apply if a patient is deemed to have mental capacity at that point. So the RC could not rely on giving against the wishes on the grounds of serious suffering if the patient has got the mental capacity to say, I choose to suffer. So I think that's quite an interesting one. In terms of challenging treatment decisions at the moment, if there are issues around treatment and care plans, the only real way forward is about going to a judicial review. So there is the intention to give more scope to the tribunals in relation to treatments. Now, what the intention is that patients will be able to apply to a tribunal about aspects of their treatment. And what would happen is this would initially go to a pre-hearing judge who would check out have they met the basic conditions in order to appeal. And I've written what those grounds are. Now, that judge will then make a decision about, is a full hearing then needed? And if so, the intention is that the full hearing will just be a judge sitting alone, which I think is quite interesting if it's about a challenge to medical treatment. However, what the consultation is saying is that the judge will only be considering the process by which the RC has made their decisions, right? And whether a decision of the RC to overrule patients' wishes is justified and appropriate. So a judge can make a finding that the RC reconsiders their treatment decision, and they're also considering allowing the tribunal or the tribunal judge to order that a specific treatment is no longer given if the judge is satisfied that it disproportionately interferes with patients' rights. So again, I think there's going to be a big drain here upon mental health review tribunals. So again, I think it's really positive about giving people much more right, but then that equally needs to be backed up by proper resources. If we move on to the NP, or the nominated person. So at the moment, people who are detained under the Act, nearest relative is quite important. It's been around for many years now, deemed to be very outdated. So the intention is to get rid of the nearest relative and replace it with a role called the nominated person. And what that nominated person, who they are, the patient will decide who they want to be for their nominated person. So when a person is being assessed under the Mental Health Act, the person will be asked to identify who they want to be their nominated person. So again, that could be anybody. And similarly, a patient could put who they want to be their nominated person as part of an advanced choice decision. If during the Mental Health Act assessment the service user lacks mental capacity around who the nominated person should be, then the responsibility will fall upon the AMP to identify and to nominate someone to act as an interim nominated person. So we'll go from an NP to an IMP, and they will remain the interim nominated person until the patient regains capacity so they can choose for themselves. And the intention is that government will issue further guidance should this actually become the law to AMPs in terms of who they should be appointing and how AMP should arrive at that decision. If a patient has got mental capacity but decides, I don't want a nominated person, the intention is that that will be fine, but there's still going to be some expectations where the local authority will start having to do visits to the patient to make sure that their welfare is being upheld. As is the case currently with the nearest relative, nominated persons will have the same powers around objection, applications for discharge, applications to a tribunal if a discharge is barred, applying for a patient's detention, for instance. But there also, the intention is to give them more powers. So the intention is for a nominated person to be given the legal right to be consulted on the patient's care and treatment plan, to be consulted whenever it comes to transfers between hospitals, around renewals, extensions to detention and CTOs. They'll be given the power to appeal clinical decisions directly to a tribunal, and also they'll be given the powers to object to the implementation of community treatment orders. We think about patients within the criminal justice system. Currently, under most circumstances, those within the criminal justice system don't have a nearest relative. But the proposing is to change that and for individuals to be given a nominated person, but with much less powers, which seems to be much more focused around the care and the treatment, for instance, around the reviews, care plans, etc. But again, the white paper doesn't really go into any detail about what those limited powers would be. When we're talking about young people, so the proposal is for 16 and 17-year-olds, they will be able to decide who they want to be their nominated person, and they will be treated as though they are an adult, so long as they've got mental capacity to make that decision. And again, if they don't nominate, then the AMP will nominate an IMP, an AMP and an IMP. If, however, we've got someone under the age of 16, they will also be allowed to choose and identify who their nominated person should be, so long as they are deemed to be GILIC competent to make that decision. If the child, young person, decides that I don't want my parent to be the nominated person, that does not replace general parental rights and responsibilities. There's still going to be provision, as there is with the current nearest relative, to overrule the nominated person. But when I've read this, it seems a little bit unclear, and I couldn't really work out what they're actually proposing, because what they're saying is that they propose that the nominated person can object, but can be temporarily overruled rather than removed or displacing, so they can continue to play a role in patients' care. So I don't know whether they're meaning the decision only around the detention, for instance, could be overruled, but you will still get access, for instance, to the consultation around transfers and have a role in the care and treatment plan. So just that's a bit of a grey area. And at present, if a nearest relative is to be overruled, an application has to go to the county court. So they're considering changing that. So the applications will go to a mental health review tribunal, and the decision to overrule will be done by a single tribunal judge. The intentions are to strengthen advocacy. So the role of IMHAs is proposed to be enhanced. Again, important in order to support patients, so they can play much more role in the care planning. They'll be playing a role to help prepare advanced choice decisions, but advocates will also have the power to challenge and apply to a tribunal, especially regarding treatment decisions, if they believe it's not in the patient's best interests, but also be given the power to appeal to tribunals. There's also going to be, the proposal is rather, that advocacy will play a formal statutory role for informal patients as well. The government's wanting to look at the quality of advocacy services which are currently provided. One thing that the government is toying with at the moment is whether to professionalise the role of advocates. So they would, for instance, have a professional regulator and inspections like Social Work England, for example. But there is some counter argument to that, because it's felt that the more of the informality of IMHAs seems to work, whereas if we professionalise it, there is a risk that service users and patients may feel that they're just, again, part of the bigger mental health system and that they're not really independent. And some of the smaller advocacy services, they've expressed concern that if they do professionalise it with the regulation, inspections, etc., that's likely to bring a lot more financial risk burdens upon them, and that they may no longer be able to function. But again, that decision has not yet been made. The government is currently trialling some alternative advocacy provision, specifically focusing upon more culturally appropriate advocates. Pilot program has already been launched around this, but the intention is that if it works well, for it to be rolled out broader. And similarly, the government's wanting to improve the standard and the quality of advocacy which is provided for people who've got a learning disability and autism. In terms of community treatment orders, the government's wanting to change a number of things here. There's a lot of concerns about the overuse of CTOs, for how long people are on CTOs. For people from Black, Asian minority ethnic groups, they're 10 times more likely to be subject to a CTO compared to white individuals, for instance. So again, the criteria is going to be changed and to be fitting more in line with the new criteria that I mentioned earlier around Section 3. There's going to be a requirement that there's got to be much more evidence to demonstrate that the CTO will be of a therapeutic benefit to the individual. And again, the emphasis is that people should not be being made subject to CTOs lightly. Third decision maker is going to be introduced for the making of a CTO. So the intention there is you would have an inpatient RC, that there would be an AMP, and that there would then be a community RC, who the 3 people are expected to be part of that assessment and decision making. And similarly, is that every time that a CTO gets renewed, there is an expectation that there will be 3 people doing that review. But I'm not entirely sure how that works. If, for instance, you've got a responsible clinician who works the community and into the ward, so you just have obviously the one, and then when people do come out of hospital and they're in the community, they'll no longer have the inpatient RC. So who would be the other RC, the third person in the community? So like I said, I'm not sure how that really is going to work. Extending CTOs is going to require AMPs and community supervising clinician, as I've mentioned. But a particular key difference is that going forward, the government's wanting to set an expectation that CTOs should end after 2 years. Although they do recognise that for some individuals, they may need to be on it for longer, but as a general rule, the expectation is a CTO should not be longer than 2 years. The nominated person will be able to object to CTOs. The AMP will be able to take action to overrule. Mental health review tribunals will continue to have powers to discharge, but again basing the decisions upon the new statutory criteria. But they'll also be able to challenge, more than what they currently do, RC's justifications for why certain conditions are imposed. Tribunals will have the power to recommend changes to the CTOs, but they will not be able to recommend changes to any conditions that actually directly impacts upon their treatment. The criteria to recall, again, is to change, so it's only going to be possible when a recall is necessary if there is this substantial risk of significant harm. And the government, again, is wanting to expand where people could be recalled to. And my understanding is that they're talking there, for instance, it could be a recall to an outpatient clinic, GP practice, or so they're wanting to look a lot broader than that. I think what is important, though, is that there is a concern that the clinical benefits of people being on CTO is lacking. And there have been calls to abolish the CTOs completely as part of this review. So what the government is aiming to do is reform and review them after 5 years. And they're hoping to see a significant reduction in the use of CTOs over that 5-year period. The interface between the Mental Health Act and the Mental Capacity Act, that the government is wanting to try and offer more clarity on this. So we've got Liberty Protection Safeguards, which will be coming soon, but at the moment people may be aware that there's often this tension that if someone needs to be in hospital against their will, should it be a DOLS or should it be Mental Health Act? What the proposal, broadly speaking, is that if you're objecting, that is going to be the key thing. So if you're objecting, it's going to be around the Mental Health Act, but if you're not objecting, but you still need it and you're going to be deprived, then the expectation is that it will be done under LPS. But again, the government is consulting about that. And you also have to bear in mind that normally for dolls it's about risks to you, not about risks to others. So they may be looking at changing the legislation around that as well. They're considering allowing individuals to be able to consent in advance. So again, in effect, like the advanced choice decision, that if I ever need to go into hospital for mental health treatment, but I've lost mental capacity, then I permit you to bring me in. All right. So in other words, I'd be going in as an informal patient, even though I may be being deprived of my liberty and lack capacity. But there's concerns to that because it would mean that you're not going to get any safeguards in terms of, for instance, going to a tribunal, because at that point you'd be deemed to be an informal patient. A&E, the wanting to give more powers to A&E. So A&E will be able to deprive patients of their liberty and to stop people leaving. Now apparently there's going to be some changes to the Mental Capacity Act, which is going to allow health professionals in A&E to take steps to deprive someone of liberty if it's necessary to provide life-sustaining treatment or prevent deterioration. But what they're saying is that that's not going to apply if it's about a mental health assessment that is needed. So they are considering extending the current powers under Section 5 to not only be around inpatients, but to also apply for people who are in A&E. Patients within the criminal justice system, I've mentioned already that the criteria is not going to change to what it currently is. Nominated person they will have, but they will have limited powers. Changes proposed to the detention criteria for learning disability and autism will not apply to Part 3 patients. So where we've got individuals who have committed particularly significant crimes and it's pure LD or pure autism, for instance, people will still be able to be detained under Part 3. The government is looking at whether to try and align the powers around mental health orders to both the Crown Court and the Magistrates Court, so they may be able to do more or less the same. And they're wanting an expectation that patients get moved from the criminal justice system into hospitals promptly. So I think what will prick quite a few ears up, particularly with my former Rampton colleagues, is that they're wanting to introduce a 28-day time limit, which is going to be split into two. So they'll be given 14 days, the hospital will be given 14 days to carry out a psychiatric assessment from the date of initial referral, and then they will be given a further second 14 days for the actual transfer of that patient to take place. That would be interesting. They're considering bringing in a new role to help facilitate the transfer of people from prison into the secure hospitals, and they are saying that they're wanting this role to be basically the analogous really to the role of the AMP. So one question the government is asking is that should this be a role that AMPs should take on top of what they ordinarily do, or another option is to create a brand new role. I think it would have to be the latter personally, but we'll see. Government's wanting to basically stop prisons being used as places of safety. So at the moment, courts, you'll be aware, are often having to send people to custody, even though the person needs to be in hospital but there's no bed available. So the intention is for some legal framework to be put in place that ensures that if somebody does go to prison under those circumstances, that the court can be assured that they're only going to be there for a very short amount of time and then they'll be moved on. For restricted patients, they're wanting to give tribunals more power, so you can make statutory recommendations to the Secretary of State around giving leave and transfers. Around social supervision, there's a recognition that there's a lot of confusion up and down the country around who should do this, where the role sits, and although there is some guidance out there, there's still a lot of different interpretations. So the intention is to strengthen the role of the social supervisor, and that is to also include specifying which professionals will be allowed to undertake the role, what approval and training professionals will need to have to do social supervision, and any particular qualifications that those people may need to do the social supervision. At the moment, it's unlawful to discharge someone under for instance, a conditional discharge or on a community treatment order into conditions that amount to deprivation of liberty. There's been some legal challenges about that not so long ago. So the government is intending on bringing in a new forensic order, so there would be still absolute discharge and conditional discharge, but they're considering bringing in a supervised discharge, which will be a legal means of discharging someone, discharging a restricted patient to conditions which amount to a deprivation of liberty. That will have to be reviewed at least every year by a tribunal, and that would only be available to those who are restricted patients, irrespective of whether they've got mental capacity or not. So that's a potential there for the supervised discharge. They want to give more powers to victims. So again, just generally speaking here, that the government is wanting victims' voices to be given much more prominence. I think what I'm just going to particularly flag up here is just a little bit halfway down, is that the government saying that they're currently exploring how they can ensure that health professionals who are responsible for providing information to victims understand their role. And they're also suggesting potentially putting the responsibility for updating victims and updating victim liaison officers, whether that should sit within a person's mental health legislation team. Again, I'm not going to make any comment about whether that is appropriate or not, but that's one of the things that's been mooted. But they're also thinking around allowing victims to be able to submit and read victim impact statements for tribunals. The intention being to help tribunals understand why certain conditions are being sought. So I think at the moment it's quite limited in terms of getting feedback in terms of what conditions you want, so this is going a bit step further. And the fact that they're talking about reading a victim impact statement suggests around being able to attend as well. I'm really conscious of time, so I'm whizzing. Mentioned around people with a learning disability and autism. Basically, the government wants to try and stop this where it can be avoided. So I've mentioned earlier on that detention under the Mental Health Act purely for autism and learning disability will not be allowed under a Section 3. People will be able to be detained with a learning disability or autism under a 2, where the behaviour of that person is so distressed that there is a substantial risk of significant harm and that there is a probable mental health cause to that behaviour. So basically what that's saying is you can bring people in as a means of assessing to find out what's the cause. And if it's a mental health problem which is the cause, then the person could then potentially be subsequently detained on a 3. But if it is not a mental health factor which is the cause, then they will not be able to be detained under a 3. And again, this is only applying to civil patients. CTR is going to be put on to much more of a statutory footing. So again, is that there's going to be much more of a requirement that CTR should be being done regularly, and that the RC, if somebody is detained, that they're going to have to consider the views and recommendations which are put within CTRs. Better services in the community. Again, That's not a secret. The government's been talking about that now for quite some time. But again, there's the acknowledgement around new burdens, financial burdens rather. But again, the government's wanting people, organisations to work much more closely together. This one around pooled budgets, again, that is happening in some areas, but they're wanting it to happen much more frequently, especially for people with a learning disability and autism. We mentioned already that the rights for children and young people are going to be strengthened around them, for instance, being able to identify their own nominated person. They're also, as mentioned, with the advance of choice documents, refusal of treatments, for instance, all of that will still apply. But if you've got a young person who is receiving mental health inpatient care, then the intention is that it must still have one of the statutory care and treatment plans, whether they are detained or not. More guidance is going to be issued just to help people assess issues of mental capacity for young people in the ages of 16 and 17, and also the fact that the government's clarifying that if you're 16 and 17, parents cannot admit you, the hospital cannot admit you on the basis of your parents. And mentioned already again around GILIC competence for under 16-year-olds. New guidance and framework for race equality is intended to be brought out within the legislation. Again, my understanding is that there's currently some pilot projects which are taking place, but with the intention of rolling out based upon the feedback. Government is wanting to bring in more provision for ambulances, and it is introducing new mental health transport vehicles to reduce ambulance conveyance or conveyance by the police. I think that's really good. And obviously, in many cases, you don't need a 999 ambulance with the defibs, etc. So if they're looking at some form of new transport, that would be brilliant. But of course, what we don't want to do is get into the old days of the white van coming. So need to avoid that one. So to conclude, and I've done a whistle stop, but a wide range of changes are proposed to the Mental Health Act. Predominantly they're non-forensic related, as I've demonstrated, but there are going to be some changes if it goes ahead which will affect people on forensic orders. There's going to be much more powers given to patients. The detention criteria is going to be tighter. People are going to choose the nominated person. People will be able to make more applications to tribunals, be able to make more challenges to treatments that is being given to you. But, and this is the but, have to bear in mind, as I mentioned at the start, a lot of this may change depending upon what the formal consultation feedback is. So the Trust, Nottinghamshire Trust, could, if they're not doing so, be part of that formal consultation process. Obviously the government's response to this, and it would still have to go through parliamentary processes, so MPs and the Lords may be wanting to make changes, make it tighter, make it looser. But there is one sentence within the white paper which I think is really critical, and it's just hidden in a very big paragraph that says all of these recommendations are accepted by the government with the caveat of it all being subject to the spending review. So that's my cynicism as to why I set off saying, is this a new dawn in terms of giving people much more power, much more control, much more direction for service users, or actually is this another case of, well, we've been here before, it didn't come to anything apart from tinkering around the edges. So the final thing I'm going to say really is watch this space. And I've finished.
Thank you, Jamie, for fabulous whistle-stop tour. It was breathless. I think
I'm really conscious that there's a lot in. I'm really conscious, Lynn, that there's a lot in there. I'm happy if people want the slides. I mean, I think that we are in a process of doing a formal response to the consultation. So some of these slides are obviously part of that process that I'm actually going to be starting next week within our trust. But like I said, I'm happy to share them. But I do apologise, it was a whistle-stop tour, but hopefully it's going to give people a little bit of, I wanted people to be able to see that actually this is covering quite a very broad range of different things, and it impacts upon so much. I think it would be really good for instance, like your carers forum, once more is known about what these new laws are going to be and what powers they're going to get.
There is a national event for women forensic social work on the 13th of April, being coordinated by David Cochran from Broadmoor, so invites will go out to forensic social workers. If anyone else wants to be involved, then if you email me about that. So thank you, that concludes our events for World Social Work Day. Thank you to those of us who've dipped in and out throughout the day. Thanks for those who've stayed with us. I think it's been the start of a journey to enable us to connect to social workers, and I think, you know, things like the Mental Health Act are the sort of things that we can all relate to, even though we see different bits of them as we do our day-to-day jobs. But thank you, Jamie, particularly, and thank you to any of the other presenters who are still with us. And we will meet again as social workers as part of Notts Healthcare Trust. So thank you all, and bye.